Bellis versus Bellis. GR number L-23678, June 6, 1967. This is for persons and family relations, particularly paragraph 2 of Article 16, the Civil Code of the Philippines, which provides that intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights, and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property, and regardless of the country wherein said property may be found. Facts of the case. This case was about the opposition of the illegitimate children in the partition of the estate of their deceased father. They argued that they were deprived of their legitimes as compulsory heirs of the deceased. Their father was a U.S. citizen from Texas state. He lived and died in the same country. The subject properties in the case were situated in the Philippines. The lower court denied the illegitimate children's opposition by applying Article 16 of the Civil Code, where the nationality of the deceased shall prevail, and since Texas law does not provide for legitimes. On appeal, the illegitimate children raised the following arguments. First, that their case falls under the circumstances mentioned in the third paragraph of Article 17 in relation to Article 16 of the Civil Code. And second, that the deceased executed two wills, one to govern his Texas estate and the other his Philippine estate, as said deceased intended Philippine law to govern his Philippine estate. Issue: which law must apply? Texas law or Philippine law? The Supreme Court said Texas law must apply. Paragraph 2, Article 16 of the Civil Code provides that intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. In this case, the nationality of the deceased was Texan. Hence, the Texas law, which does not provide for legitimes, must be observed. The argument that paragraph 3 of Article 17 of Civil Code is an exception to paragraph 2 of Article 16 of the same code was incorrect. The Congress deleted the phrase notwithstanding the provisions of this and the next preceding article when they incorporated Article 11 of the Old Civil Code as Article 17 of the New Civil Code, while reproducing without substantial change the second paragraph, Article 10 of the Old Civil Code as Article 16 in the New Civil Code. It is therefore evident that whatever public policy or good customs may be involved in our system of legitimes, Congress has not intended to extend the same to the succession of foreign nationals, for it has specifically chosen to leave, among others, the amount of successional rights to the deceased national law. As to the argument that the deceased's intention by executing two wills was to apply it accordingly in the country where the properties were actually situated, the court also ruled the same in the negative. As held in Mishano versus Brimo, a provision in a foreigner's will to the effect that his properties shall be distributed in accordance with Philippine law and not with his national law is illegal and void, for his national law cannot be ignored in regard to Article 16 of the Civil Code. In other words, the intention of the deceased is immaterial. Therefore, in this case, the execution of two wills by the decedent was of no moment because Article 16 of the Civil Code provides that it was his nationality that must prevail. In applying the foregoing, Texas law must apply.